I realized I was just talking to everyone with my microphone muted, so let me do a quick summary of what I had said. First, this is the policy meeting of the Commission on Sentencing. The meeting will be covering 4 proposals that the Commission had public hearings on. The Amendment 6 to the Sentencing Guidelines, Amendment 1 to the Resentencing Guidelines, Initial Parole Guidelines, and Initial Parole Recommitment Ranges. And so the Commission approved proposals and scheduled public hearings and held public hearings during the past month. We held 4 public hearings. The hearings had a physical site, but the hearings also were held by Zoom webinar, and we had fairly good attendance at the 4 hearings. And so, so today, what we hope to do is spend about a half hour on each of the proposals. Diane Shoup has prepared for us a summary of issues raised during the public hearings that relate specifically to each of the proposals. Those have been distributed to members, and all of these documents are available on our public website. So anyone in the public wishing to look at those documents while we're having this meeting can go to our public website, which is pasentencing.us. And in the news section, the top item is meeting materials for today's meeting. And so those documents are available for others to view. With that, I'm going to turn it to Judge Bernstein to get us started with the review of the proposals.
Well, good morning. I just signed on, but I don't have the proposal in front of me yet because when I walked in this morning, my computer is missing. Yeah, I'm on my iPad. We had a computer problem and they took it for tech to get it back up. So I'm trying to pull everything up off of my phone. So I know that's not super helpful, but that's where I'm at this very moment. I apologize for that. I just had them come over to find out why I don't have my computer. So, I mean, I'll call the meeting to order, but I can't go through anything else at this point.
That's fine, Judge. I can, as long as the meeting's now in order, what we'll do is start with a review of the proposals. As I said, Dr. Shoup has prepared a summary of issues raised for each of the 4 proposals that were out there. And we're going to spend this first half hour focused on the 7th edition guidelines, the Amendment 6 to those guidelines, and the suggestions received from the public or by staff, and hopefully identify any types of changes or modifications that the Commission would like to consider. So with that, Diane, maybe I can turn it to you. As I said, we have both a handout that was provided to each member that documents those details, but we'll try to also monitor those by going through these PowerPoint slides. Diane?
Sure. So we're going to start with 7th edition Amendment 6 sentencing guidelines that were proposed. These were published July 4th in the Pennsylvania Bulletin. In the supplemental materials, what was published starts on page 336. After publication, we had some technical changes. A lot of these relate to the elimination of some of the sentencing enhancement text that was moved from 303.9 to 303.10. So the first few bullets on that list are just to retain the number or letter, delete the text, and add the word deleted or retained. Also after, go ahead.
Diane, if I could, just to help members, I know there's a lot of stuff, it's all online and this is a little complicated, but as Diane said, if you look at the packet of materials or the file or the document that's labeled supplemental meeting materials, it's a very large volume, something like 600 some pages. And the text that we published in the Pennsylvania Bulletin of the amendment starts at page 344. So if you want to follow along, that's the document we're going to be working from. And as Diane said in her list, the first issues are these technical corrections. And as she indicated, because we were changing a lot of text in the guidelines, One thing that the Legislative Reference Bureau encourages is that if you're deleting an entire section, but you want to retain the same sort of order of subsections and so forth, you just, in effect, reserve that section. You delete it and you just note it as deleted instead of wiping out the subsection, because then the lettering doesn't follow or it offsets the lettering or numbering of things. So as Diane said, a really technical change here is in the publication, we were inconsistent in whether the term deleted was added as text or not. So all we're asking, or all we're recommending here, is we'll go into the text and we'll make that change for any of those subsections that have to be reserved so that the order of the outline remains the same. We'll just insert the word delete or deleted section. So that's the substance of that point. Diane, I think there were two corrections, those two typos in terms of the grading of the offense. Could you address those and provide the page number, please?
Yes, on page 420, it's in section 303.15, the offense listing in the guidelines. It's firearms for persons not to possess if there's an active PFA. So it's the offense 18-6105A1. It refers to penalty section C6, I believe. And we have those subcategorized into loaded, ammo available, and unloaded, no ammo available. And it was brought to our attention that there's a typo there. Those are actually M2s and not M1s. So those are corrections, again, on page 420.
Thank you, Diane. Are there any questions regarding that issue? And hearing none, what staff will do is just make modifications to our draft. And so during our business meeting today, if the commission was moving on adoption, we would incorporate these changes into the draft that would be adopted and submitted to the General Assembly. So moving on, we're going to move to issues that were raised during the hearing. And I'll ask Diane to provide a little background on each of these, but we're going to try to go through in the order of the document. So she'll again announce the page so that we can sort of get you oriented to that, to see the existing text, and then any kind of changes that we would recommend. So Diane, could you start us off on that?
Sure. The first issue raised is a prior record score calculation. This is sections 303.4 through 303.8, pages 347 to 351 in the supplemental materials. As we've talked about, we want to address stale records and aging out of the criminal behavior in the prior record score, but this will probably not happen until we do 8th edition, since it's quite a big undertaking. The second point was...
let's just do one at a time, Diane. Okay. So on that issue, as Diane said, we've been working a long time on these, this rebuilding of the guidelines, what we envision as the 8th edition guidelines, which we expect to be drafting in the next year and trying to move to public comments. But there is a lot of work involved in rebuilding the prior record score, not just building in a lapsing provision, but some of the things built into the proposal right now are to really recalculate how we do prior record score. So there are a lot of moving parts there. And so I think a number of individuals commenting on the guidelines indicated to the commission that this was a missed opportunity, that the commission could have done a lot to start advancing those changes in prior record score. And I think staff agrees that we need to address that. But this is an amendment that focuses on incorporating changes based on the Justice Reinvestment Initiative legislation. And what that legislation did was two things. It repealed two sentencing alternatives, county IP and state IP. Our current guidelines are built around having those as sentencing alternatives. So we had to take as quick action as possible to eliminate those from the guidelines. And then the second thing JRI did was it created mandates where it said to the commission, you must adopt new guidelines for probation and for probation with restrictive conditions. Well, they don't exist at all, and this amendment intends to put those in place. So that was really the primary focus of this amendment, trying to do those immediate changes that were necessary related to JRI 2. But I think commentators were on point in terms of where the commission is in saying prior record score has to be redone, and that's part of the 8th edition guidelines. So that's why it is not part of these recommendations. So let me just stop there, because that was an issue that was raised during hearings, and turn it to the judge in case there's any comments or discussion by members.
Any questions? I'm scrolling through. If you have any, you can just unmute and speak up. I've scrolled through. Nobody's indicated that they have any questions. So you can go ahead.
Thank you, Judge. So Diane, the next section or the next issue related to, I think, probation guidelines.
Yes, this is 303.9. There are 3 subsections involved in capping probation at 1 to 2 years.
Diane, the page number?
Well, it's page 354.
Okay, thank you.
And also regarding the term shall rather than recommend, in order to avoid mandatory language, we wanted to use recommend. So the first is 303.9 E5 III. We inserted recommended between the and duration and changed shall to may. Again, that's page 354, 303.9 E5 III. The second place we did that is 303.9 F1 II. Again, we used recommended duration and changed shall to may. And in 303.9 F1 III, we inserted recommended for aggregate term of probation and changed the shall to a may and made a technical correction and spelled out 5. Again, on page 354.
Thanks, Diane. So there were 2 issues raised. So this issue about the language, the use of recommended and may instead of shall, was something the commission talked about in June during the meeting, and said that the language we had felt a lot like mandatory language. And the argument was, well, within the context of the guidelines, we were trying to be very clear about what the guidelines intended. But we received that kind of comment from others as well during the public hearing process. And so staff has recommended building in recommended and changing shall to may, but we think the general substance of this is the same. The other issue, and I'll just throw it in as far as the probation guidelines, a number of people thought that the duration of probation that we were recommending was too high. If you recall, at level 2 of the guidelines, we have recommendations based on specific offenses for duration of probation of either 1 year or 2 years. But then we have a broader policy that applies to a sentence imposed during a sentencing hearing, the aggregate sentence. And what the commission has basically recommended is, if there are no restrictive conditions of probation imposed, the aggregate, the maximum period of probation should be limited to 5 years. And if there is probation with restrictive conditions, house arrest, electronic monitoring, things like that, that the duration of probation should be limited to 10 years. And commentators thought that, or some of them thought that was too high. We should have lower durations. I think the one comment I would make is, when we've looked at aggregate sentences of probation imposed by courts in recent years, there are cases that go up to 70 or 80 years of aggregate probation. So the idea of having any guidelines in place for a first time and to sort of limit it down to 5 or 10 years is, I think, we were trying to sort of find the right balance, the right part. But I understand the arguments about even having shorter durations. But those were the issues in play. The other thing that we talked about during the June meeting was that some of the research about duration of probation it depends. It depends what you're looking at, but the research on redemption about when does someone return to sort of the status quo ante in terms of criminal offending, some of that research looks like an 8 or 10 or 12 year period of time, depending on the nature of the offense. So I think there was some justification for a 10-year max for those more serious cases. And that may include cases that are split sentences. So anyhow, I wanted to give you that summary. I'll turn it back to the judge for any comments or discussion by the members.
If anybody has any comments, please just unmute and state your name and we'll address them.
Dave Sunday. Hey, just real quick question, and you probably don't have the answer for it, Mark, but if the guidelines were okay, if the proposed guidelines were enacted, what do you have any idea? And I'm not looking for a specific. I know you probably definitely don't have it, but what percentage of current sentences do you think would be out of the guideline range? Like, I guess really what I'm seeking is just out of curiosity, what do you think the real impact of this would be if we sort of overlapped it with how sentences are currently being done right now?
That's a good question. I think let me just. I don't have a specific response in terms of percentage, but I can tell you about some of the things that may change. One thing that is common that we often see is in cases where there are lesser offenses that do not merge. So think about burglary and criminal conspiracy. It's not uncommon to see a court impose a confinement sentence and maybe even a split sentence on the lead count on the burglary. And then on the criminal conspiracy, impose a concurrent period or consecutive period of probation of about the same duration. So it's not uncommon to see, 5 or 10 years of probation imposed on those types of felony offenses. And it's almost just sort of built into the process. But the real issue is whether it's concurrent or consecutive, right? Because if it's consecutive, it's adding on a lot of time beyond the tail on the confinement. So we see that quite often. We can certainly do, frequencies or distribution of probation duration, but when we did that, we did find a lot of outliers. And so I think, guidelines tend to provide this common starting point, and just having them in place, having people think about probation, I think starts to pull things more towards the center. And so I think that's what what this could be as a first step. I guess the other thing that I'd mention is, let's not disconnect Amendment 6 from this 8th edition guidelines, because to some degree, some of the stuff that we've built into Amendment 6 is like a launching pad for making sure we consider or build those in or refine them in the 8th edition guidelines. So I think this is like a starting point for that. And so we can certainly try to find that information that you're asking about, but I don't have it off the top of my head.
No, I mean, that's very helpful, Mark. Thank you.
Sure.
Yep.
Judge, you're muted. Yes, I was muted on purpose. Oh. My staff just came in. Is there anybody else who has any comments on that? So I guess my question is, we'll have some, by the time we hit the 8th edition, Representative Stevens just joined in, but by the time we hit the 8th edition, we should have some numbers on how this looks with what we've done with this amendment. regarding the issue that we're just discussing on the probation?
That is correct. We should be able to, and in fact, we can certainly provide the baseline information now. It's just we'd have to run it. Like I said, we've done that before, and our focus was on these outlier cases. But I think we could certainly look at that analysis and answer sort of the question that the DA raised in terms of just like what's typical, and then to your point, what would we expect? We could start looking month to month from reported sentences under the new guidelines to determine if there's been a change and what courts are doing. As I said, this will be the first time there would be any consideration under the guidelines of probation duration. So that's a substantial first step.
And this may go more to Ryan than to you, because I think it's more of an education and outreach type issue. But I guess always my concern, and some of the things that I may see locally, are where people get these ridiculously long probation periods for things that just don't seem to fit. And I think that there's a lack broadly of knowledge about what recidivism looks like in terms of, like you said, some data shows the redemption or the status quo, which I guess puts you at a place where you'd be equal to somebody who's never committed an offense, can be 8 to 12. But my understanding on some of the other things we've discussed is certain areas are, it's within 3 years.
Sure.
And I just don't, how do we get that information out? Because I feel like sometimes the sentencing is, that's the way we've always done it, or this looks tough, or this belief that it's necessary to prevent somebody from committing more offenses.
Sure. Well, I think one thing is to have something in place, because right now there are no guidelines or standards around the duration of probation. So I think that's one thing, to have some kind of structure in place as a starting point, and then we can continue to modify that as it's warranted. So I think that's it. I think you're right about looking at the particulars of the case, because you're right, for less serious offenses, for individuals that are low risk, low needs, much shorter durations make a lot of sense. And so, Senate Bill 14, a lot of other legislation has some great ideas regarding, duration and that, and that's, I think, part of the mix as well. But as I said, the redemption legislation is maybe more cautious in terms of looking at that returning to the baseline. And even there, though, the difference on duration has more to do with the nature of the offense. So certain offenses have would warrant longer periods of probation than others, not necessarily linked to the grade of the offense. But I think you're right about, Ryan and his team, building this into the outreach efforts, and especially educational opportunities with judges and practitioners, so that they're thinking about that kind of research on like what works.
Okay, thank you.
Good morning. This is Judge Tucker. I totally agree with Judge Bernstein. As the supervising judge in Philadelphia County, the criminal section, oftentimes I will see sentences imposed by non-sitting judges who have retired or passed. And oftentimes not oftentimes, but sometimes the sentence may be like 38 years of probation, or 40 years of probation, which it in my mind serves no purpose at all. So I agree with Judge Bernstein on this.
Thank you, Judge Tucker.
And one of just to the judge's point, one of the things that can build into this, and especially if you have a starting line like you have probation guidelines in place, is trying to use the changes in statute that allow courts to terminate probation supervision, because that's an underutilized, or that's a practice that is sort of county specific. Certain counties are willing to terminate probation supervision, and other counties are resistant to doing that. And so, as the judge said, you can have someone with a 30 or 40 year probation term, and in one county, they'd have a process whereby they'd review that and they'd terminate that at some point. And in other counties, they're honoring the original deal or the original sentence, and they won't do that. So putting guidelines in place to try to avoid that in the first place, I think, is helpful. And then looking at things like some of the legislation in the Senate, Senate Bill 14, and other reform legislation, because some of that is a back-end provision about these reviews and terminations. But we should be trying to promote better practices at the front. So. If nothing, I also see Senator Street has joined on the call, so just wanted to make that a part of the record.
Mark, let me just jump in one more time. I think that if in doing this, if we consider, I want to use the term aging out of criminality. At some point, usually we see the individuals between, say, the age of 18, 34 or so in our courts. And after that, when you don't see as many people in Philadelphia County, at least, in the ages of, say, 50 or 45 even, you don't see that much people in that age bracket. And I think that's perhaps something that somewhere or another should be considered when we look at this, in terms of when a person reaches the age of, say, 50 or so, in that neighborhood. I think they kind of get it that, I'm human, I got to live, and I got to stop the foolishness. Now, that doesn't happen all the time, but I think that's an area that probably we should plug in and look at that as well when we look at the length of probation.
Sure, Judge. And I think that ties into what we talked about with the 8th edition rebuild, because one of the big drivers on our recommendations is the prior record score. And if we do a much better job at not only reducing the impact of the prior record score, but also taking into account those lapsing provisions, which get to the age issue, I think we reduce the sentence recommendation substantially, and that could apply not only to decisions about confinement or duration of that, but also to probation. So I think that's a really good point. I think, as I said, I think that the first point for the commission in even having probation guidelines proposed is trying to figure out what that aggregate recommendation would be. What's sort of the recommended cap on the use of probation. And, the commission got to 5 and 10 years based on what I mentioned. But, that's certainly, we received comments about, cutting that back. And then the question is, what do you have as guidelines for sort of a starting point for consideration by the court versus what does the judge individually decide in a specific case? And I think that's where you can exercise discretion in saying, this is an older person, that the use of a really long period of probation doesn't make any sense at all. Even Mark, 10 years is too long.
Yeah, Mark, I just want to,
I'm sorry, Senator Street, go ahead.
Yeah, I just wanted to add that the considerations that Judge Tucker has mentioned have also been debated in the legislature, and there's bipartisan agreement, although not on the exact language of a bill. But I have a bill, Senator Baker has a bill, that looks at geriatric parole because of the two factors that at some point people age out of the risk of recidivism drops precipitously, and the cost of incarceration increases precipitously. And so the cost to the Commonwealth and to the people of incarcerating people once they reach a certain age goes up tremendously, and the benefit to society because it drops because these people are much less likely to commit a crime. So if we're developing a tool, I think having something to reflect that reality would be helpful. I'm not certain I have language as to what that reflection is, but something that reflects that reality would be very helpful.
Yeah, thanks, Senator. I think that's a really good point, and all the research supports that in terms of aging out and things like that, criminal careers and what have you. So I guess the question is, how does that like fit into this? And as I said, right now we're just talking about probation guidelines and initial probation guidelines because they don't exist at this point. And just thinking about what is as a starting point for this, what is the duration that makes sense? So we've already separated out probation from probation with restrictive conditions. Yes, Judge Marsico.
But won't a lot of this, won't we have to take, and, I'll defer to our legislative colleagues. I know they're working, expect some things to be coming, I believe, sometime this fall with regard to probation reform. Will we have to change course once that happens, or what are your thoughts, or senators or the reps' thoughts on that?
So Senate Bill 14 cleared the Senate with overwhelming support from both parties. I'm not sure what's happening in the House, but I suspect it will pass out of the House. Like I said, it was bipartisan bill, Bartolotta, Williams bill. I'm a co-sponsor on it. But we had the Republican chair of the Criminal Justice Reform Committee and the Democratic state government chair co-sponsoring the bill, overwhelmingly passed the Senate. So I think that's a good starting point for what the legislature is likely to do, because that bill passed, like I said, with overwhelming majorities out of the Senate.
Senator, I think that's a good point. And Judge, I agree. One thing to keep in mind, though, and at least in the last printer number of that bill that I saw, it's a back end provision. It's about bringing cases before the court for review to basically to eliminate the probation, not a front end. So we're trying to provide a front end.
Gotcha.
Yeah. Can I jump in here?
Please.
It's no. Well, I just wanted to throw 2 cents in. I have not actually heard any conversation in the Judiciary Committee about that bill for a while. So it's been sitting over here for a little while, but I just haven't heard any conversations about it at all. So I don't know if we should count on that getting to the finish line here in the next 2 months or not. And at the risk of bringing up opening a whole can of worms, how much of what we're talking about, so Mark, this is directed to you, how much of what we're talking about, because a lot of these conversations I recall from previous discussions, how much of what we're talking about is already is included within the risk assessment instrument that we adopted, and what application will the risk assessment tools that we have been talking about be implemented regarding probation and parole? Is there any overlap there?
So on the risk assessment, again, as adopted, it does include age as one of the factors, exactly for what the judge and the senator and everyone else has talked about. And so younger age has points as compared to older age. But remember, our risk assessment then is used to say, these are cases where you should give greater consideration, have more information before sentencing. And I think that really does, both on the, since we don't label it, both on sort of both ends of the spectrum, high or low risk. So to the judge's point, if someone is low risk because they're older, there'd be an encouragement by the commission to get additional information, because that might be the basis for a much shorter period of probation supervision. So I think that does sort of tie in. On the confinement and parole side, we're required as part of the parole guidelines to consider some type of validated risk assessment that's used within the department. And so that certainly includes consideration of age as one of those factors as well. So I think that is built in a way that's useful.
Thank you.
I know we need to keep moving along, so I guess the question for the members is, the recommendation deals with probation guidelines for the first time and has guidelines about specific offenses, sort of limiting to 1 or 2 years the duration of probation for that offense. and also sort of this aggregate at the time of sentencing. What's the total probation? And we limit it to either 5 years if it's just regular probation without restrictive conditions, or 10 years if it's probation with restrictive conditions. So that's what's in the proposal. And I guess the question is whether we move forward with that, or whether we move forward with that with different values, different numbers. So I guess that's the question before we move to the next issue. If there's support to just move forward with what we have.
Do you want an opinion on that? Do you want someone to comment on that for you?
I mean, so here's where the sort of the rubber meets the road. We have a proposal that was approved by the commission. We publish it and have public comments. There's comments around the duration of probation. And in the next meeting, the commission will either vote to adopt or vote to delay action. So, this is just one of those issues. We don't have to decide at this moment, but it's one of those issues that if we're going to move forward with adoption, we need to know if this is okay. If what the commission approved, the commission wants to move forward with. So feel free to, just sit on that for now, and we can move through some of the other review. And when we come to the commission meeting and move to whether to adopt or not, we can revisit the details of this. But we wanted to have this opportunity to review what we heard and to see if there's any comment. And this has been a good discussion. But I'm also sensitive to time, that we have to keep moving this along. So how about if I just move on to some other issues? You think about that, and when we come to the commission meeting, we'll come back to that probation clause.
Page 372.
Okay, so let's move on. And Diane, the next issue is?
Page 372, it's section 303.12 F2, adding some language regarding the consecutive sentence of probation to exceed the statutory sentence maximum. So we inserted a new subsection here. The court may impose the period of reentry supervision required in addition to the maximum sentence permitted for the offense for which the person was convicted. Again, that's on page 372.
And this issue is fairly technical. I think Attorney Suss raised this issue about just parallel language, about making sure, because in both of these circumstances of the state reentry supervision and the mandatory probation for sex offenders, that the added time can be greater than the statutory max. It can add on to the statutory max. And he thought it would be helpful, just for clarity, to have the parallel language in those two sections. So doesn't change the substance of the recommendation, just adds clarity, I believe. So if there's no objections with that, I think we have two other issues we're going to quickly go through and then move on to resentencing. The first is that there were a number of bills enacted since we published these proposals, and we usually try to be timely in terms of incorporating those into the guidelines. These are basically omnibus policy provisions. So either we already have this offense in the guidelines and we're using the existing assignments for the grade of the offense to come up with the new assignments, or these are entirely new offenses and we just use the omnibus score. So Diane, could you just very quickly review those? We would want to just incorporate those into this, this amendment to the guidelines.
Sure. This is page 278, Act 40. And it is operating a watercraft under the influence and having a passenger under age 18. It applies to Title 30, 5502, and a number of subsections. It's an M1. The omnibus policy says that since we have an existing M1, the OGS 5 would apply. This bill also creates a new offense, aggravated assault by watercraft with serious bodily injury. It's 30-5502.4. It's an F3, so the omnibus score of OGS 5 would apply, and that's on page 294. We also have Act 63 on page 297. There is an existing offense, assault by prisoner. This adds assault by prisoner against an employee with attempt or cause bodily injury. It's new 18-2703A1 II. It is an F2. The omnibus OGS would be a 7. That's on page 303. It also creates assault by prisoner against employee, attempt or cause serious bodily injury. That is new. It's an F1. The omnibus OGS score of 8 would be applied. And it creates a new 2 other offenses: institutional sexual assault by a peace officer, 1831-24.2, 8.41 and 2. 2 addresses victims that are specifically under age 18. They are both F3s. The omnibus policy would assign an OGS of 6, and that's on page 304.
Thanks, Diane. And under operation of the guidelines, these OGSs are assigned. So they're in place right now because that's our sort of default policy in place. But by incorporating them into this amendment, we'll actually publish them with the rest of the guidelines. So it's just a little easier for people to find and for it to be applied. So unless the commission wanted to change the OGS assignments, this would be an opportunity for that. Otherwise, we would just go with what otherwise would apply. All right, I'm not seeing any, Judge, we're good to move on that?
We are, and I don't know if so we're good on all of that.
Thank you. And the final issue we have deals with enhancements. And if you recall, we built into the amendment a couple of enhancements that were mandated by statutes, by legislation that was enacted. But there were 3 bills that were moving through the General Assembly that also included enhancements that we decided to incorporate into what we published to receive comment, and so that the commission would be positioned to act on those. It's my understanding that these bills have not been enacted. So I think it would be premature for the commission to adopt enhancements in these cases unless the commission wanted to do it under its own power, because the commission can always create enhancements. But I think it might be better to hold off on these, incorporate them into the 8th edition guidelines once we have final language from the General Assembly and we see if these are enacted.
Any comments or questions or thoughts on that?
Mr. Todd, I agree with you. I mean, there's a lot of proposals for a lot of enhancements. I have many of them, but I think, unless there's if there's a burning issue that's, occurring within the Commonwealth or something like that, I think that then it makes more sense, for us to take it up. But I don't know if we should just act based on every proposal that's introduced.
Right, fair point. And these are offenses for which we already have enhancements. These would be adjustments to the enhancements. We can deal with that during the next edition of the guidelines. So, okay, that's great. Thank you for all the comments and discussion on that. We're now going to move to the second proposal, and this deals with the resentencing guidelines. And there were, very few changes to that. The one change linked to JRI 2 was the repeal of county IP and state IP, both of which were part of the initial mandate for resentencing guidelines. Those were repealed, so we had to remove those from the guidelines. And then the other provision was a clarification where we just incorporated statutory language about consideration of time served on probation. We really haven't received many comments on this issue. I'm going to just turn to Diane quickly to see if there's anything that, aside from that we need to address because then I want to turn it to Matt and to Miranda to talk about the work with Vital Strategies, who testified during the one hearing.
Sure. On page 459 in 307.2B, we do need to add an effective date. That's just a technical correction. And then there was a question about whether we should include M3s and summary offenses for conviction that does not occur in a court of record. Act 115 permits state parole violations for that, and we didn't know if that was something the commission wanted to consider or not. That's on page 457 and 459. There was also a question on pages 459 and 460 about the use of consideration of any service of original sentence as opposed to credit for time served. And we felt that consideration is broader and more discretionary, and it's also language out of statute. And then finally, in 307.3A on page 459, there was some concerns raised about including non-incarceration alternatives for technical violations solely for drug possession and use or failure to attend treatment when there's also an underlying substance abuse disorder. And that kind of goes along with Miranda's and Deputy Secretary or Deputy Director Kleinman's presentation.
The only maybe clarification or addition that I'd add is that issue of court of record. Remember that for both the resentencing guidelines and the recommitment ranges, we use the term court of record in terms of defining when something is a conviction violation versus a technical violation. And so the idea was if someone was found to have committed a summary offense before an MDJ, that would not be viewed as a convicted violation, but rather as a technical violation. But if it was an M3 before a common pleas court, it would be a convicted violator. So that's the distinction we make between that's why we use the term court of record to distinguish matters before MDJs and CP courts on revocations. Mr. Suss, Attorney Suss raised the issue that there is case law that has basically changed that view in terms of parole recommitments, in whether the parole board could consider a conviction before an MDJ as a convicted violator, and there is a provision that allows them to do that. So maybe when we talk about parole guidelines, we raise that issue again, but for purpose of the resentencing guidelines, if you want the distinction between matters before MDJs and matters before CP judges, we keep the language we have. If not, we just eliminate the court of record language and it's before any court, and that would allow misdemeanor or felonies, whether handled by MDJs or CP judges, to be considered conviction violations.
Any other comments or thoughts?
All right. With that, we can turn it to Dr. Kleinman. He and Dr. Galvin have a presentation that addresses issues raised by testimony related to substance abuse and violations of probation. Matt?
Thanks, Mark. And I also like to thank the chair and the vice chair for providing us with a little time on today's agenda to present some of our findings from a project that has been going on since August of 2019. A lot of times the work of the Research and Data Analysis Unit is oriented and directed towards legislative mandates that we receive to drive our research agenda and what questions we're answering. This project provided us an opportunity to explore issues related to substance use and revocations and resentencing of offenders under community supervision that really paralleled a number of the efforts that the commission was looking at, especially as it relates to resentencing. Our full report can be found in the supplemental materials on page 90. It is quite lengthy, over 100 pages, and is packed with a lot of information. A detailed list of our research questions can be found on page 205 of the supplemental materials. And briefly, I just want to provide some structure of where our data sources came from as it relates to looking at outcomes or revocations and resentencing for substance use users. We utilize the Commission's resentencing database as well as our sentencing database, and Miranda in a few moments will walk through what our sample is and what we focus on specifically. We also made site visits to Allegheny County and to Center County. We had hoped to visit a third site, York County, but unfortunately coronavirus and situation made it difficult, if not impossible, for us to visit the court. During those visits, we coded and collected case level data from recently closed probation files to get a more robust set of insights about individual offenders. And then we interviewed key stakeholders in those jurisdictions, including probation chiefs and the management teams, judges, public defenders, and treatment providers. So we'd also like to extend our thanks to those individual jurisdictions for allowing us to come and especially to look at individual case files and to meet with the key stakeholders. So with that said, I'll turn it over to Dr. Galvin, who's going to talk more about the project design, our specific research questions, and our key findings from this study, which I think dovetail really nicely with the work, again, that the Commission has been doing on resentencing, but also corresponds with some of the public comments that we received about parole guidelines and the need for not only risk assessment, but needs assessment. So I'll turn it over to Dr. Galvin.
Great, thank you, Matt, and thank you to the Commission for the opportunity to present our results to you. I just want to give you a little bit of a background on where we came from, or why we wanted to look at this project and why we think it's important. So the first reason, is that most people under justice supervision are in the community. There's a lot of attention paid to in public discourse and legislatively to issues of mass incarceration. But more recently, there's been a push to look at issues of what some scholars are calling mass probation. And that's at the same time that we saw rising rolls in incarceration, we also saw rising caseloads in probation as well. Now, if you look, to give you an idea of what community supervision looks like, both nationally and in Pennsylvania, you see two charts here. On the left, you're going to see the national distribution of offenders under justice supervision, and in 2016, and on the right, you'll see the same information specifically for Pennsylvania. And you'll see that for both nationally and in Pennsylvania, about half of our individuals under justice supervision are under probation supervision. And then nationally, we have another 12% that are under supervision in the community under parole. In Pennsylvania, that number is actually quite a bit higher. It's closer to 30%. So in Pennsylvania, you have a significant chunk, almost over 2/3 of people who are under supervision in Pennsylvania are in the community. And so it's particularly important for Pennsylvania to be mindful of these issues of how substance use affects offenders who are under community supervision. Now, we also know that not only are a lot of individuals in the community, but many of them do not stay in the community. Revocations from community supervision are a substantial driver of incarceration admissions, and some recent work by the Council of State Governments has estimated that about a quarter of state prison admissions are related to violations by offenders in the community, and that includes both technical violations and for new offenses. So 25% is a significant number, and that's in state prisons. That's not accounting for the higher numbers that we expect in jail populations as well. And finally, there's a significant percentage of individuals who are justice involved that are also substance use involved. And by substance involved, I'm including not only the use of illicit substances, but also substance use disorders related to alcohol. that produce these really problematic patterns of behavior that are associated not only with illegal behavior, violations of the law, but also make it difficult for them to abide by the requirements of community supervision, specifically related to abstinence, but they may also face difficulty in getting employment and securing housing. And so this is expected to have a significant effect on probation outcomes. Now, we don't have a good precise estimate of just how many people in the justice system are substance involved. I think the best number is about 20 years old, and it's 2/3. But the consensus is that the rates of substance use is very common, and that it's much higher than the general population. In fact, in our site visits, practitioners expressed that the vast majority, in fact, of their clientele were substance involved. So as Matt mentioned, there's a long list of specific research questions that can be found in the supplemental materials. But just to give you, we had 3 kind of big buckets when we were looking at this issue. And we wanted to know first how common is resentencing in Pennsylvania. We wanted to know not just in general, but also specifically for technical violations and for new offenses. We wanted to know how that pattern of reoffending was consistent or different across groups, both racial, sex, age groups, and as well as potential differences across counties. And then finally, also within this bucket, we wanted to know how substance use affected the likelihood of resentencing. Now, our second bucket had to do with what happens when an individual is resentenced. What happens? What are the common outcomes of resentencing? Are there differences across groups? How is substance use dealt with? And again, how might this vary across geographic groups? And finally, given that we know the rate of resentencing, what happens with resentencing, what is the impact of resentencing, and specifically substance-related resentencing, on resources in the state of Pennsylvania? To look at this, as Matt mentioned, we linked a number of commission data sets, starting with our a sentencing cohort that we then linked to resentencing events. And the reason for that is we wanted to follow a group of individuals over time and then see how they fared on probation. Now, when individuals were resentenced for a new offense, we tried our very best to link to the new offense details using the sentencing proceedings that were reported to us as well. And so we're drawing on the requirement from the 7th Guidelines Edition Amendment 3 that jurisdictions report to us all resentencing for individuals who are in the community. And we are particularly focused in this report on resentencing for individuals who are under either standard probation sentence or individuals who were sentenced to a sanction of county intermediate punishment with restrictive elements, or what's now known as restrictive probation. And so we are focused on that group in particular, and we'll talk a little bit about where these individuals are on the guidelines and what they look like. So the important thing about this sample to remember is that this gives us a group of individuals who were resentenced as well as those who were not resentenced. So we have a good ability to compare how likely some groups are to be resentenced, and specifically to get at how likely or how substance use affects the likelihood of resentencing. So we started with a full sample of 2016 to 2017 sentenced cases, and we started with 180,492 cases. Of these, about 96,000 received a most serious sanction for their judicial proceeding of either probation or CIP with restrictive elements. So these are not individuals who were ever incarcerated. They've always been in the community. And there were 84,000 and change who we did not include from that group. When you look at those 96,000 cases who received probation or CIP, we matched them to the resentencing data that had been reported to us. And when we did that, we noticed a couple things, that primarily that there were I'm sorry, I'm having some technical difficulties. Okay, great, thanks. So we noticed that there were 11 counties who reported no resentencing information to us. And there were an additional 9 counties that reported such low rates of resentencing procedures that we didn't have strong faith in getting the correct rates of resentencing and the correct incidence. So we excluded those counties from analysis, which meant most of our analysis are based on these 47 counties of and 67,000 individuals who were sentenced to probation or CIP in 2016 and 2017. Now, of those 67,000, we have about 9,000 who experienced at least one resentencing event and 58,000 and change who were not resentenced. Now, this graph shows you what percentage of our sample and where they were on the grid, cell by cell. And so you'll see that for the most part, our offenders are clustered in the bottom left corner of the grid. These are people who generally have very little prior experience with the criminal justice system. About over half had a prior record score of 0. And the offenses that they're being supervised for are fairly minor. About a third had an OGS of 1. And the sample was 27% in level 1, so it's a significant proportion. And then between 1 and 2, we had more than 3/4 of our sample, 82%. And when you add on level 3, it's almost 100% of our sample in these lower levels. So again, these are relatively low-level offenders who are being supervised in the community. The first main takeaway from our report is that in spite of the fact that these are low-level offenders who commit fairly minor crimes, resentencing is somewhat common. It occurs in more than 10% of cases, and in our particular sample, it was 13.4%. And of those who are resentenced, most are resentenced only once, but there are some offenders who are resentenced multiple times. I think the highest was 3 or 4 times under their period of supervision. And we found that even after adjusting for individual and group differences, that men are more likely to be resentenced for technical violations than women are. And so we are seeing some worse outcomes for women. We did not, however, find any significant differences by race when we accounted for differences in offense characteristics and county differences. There were, however, substantial differences by county. I think that the maximum rate of resentencing that we saw in some counties was as high as 30%, and the minimum was in other counties where it was as low as 5%. And however, when you look at that difference across county class, we don't see any particular pattern. You see the state total of 13% in the black bar on the bottom of that graph. And most county classes cluster around that, with the exception of second class Allegheny, and that's just because it's a single county that's not averaging out. What happened when in these resentencing proceedings? And while most people who are resentenced are giving a most serious sanction of county incarceration, so more than half receive at least some county incarceration for their violations, extension of probation is also common during resentencing hearings. And some of the individuals who receive county incarceration also receive a sentence of probation. State incarceration is relatively rare, as is intermediate punishment. Those who do receive intermediate punishment sanctions are generally receiving county intermediate sanctions, usually looking at house arrest and electronic monitoring. These are not usually people who are being sent to treatment programs or being sentenced to restrictive conditions. And importantly, the rates of outcomes are pretty similar for people who are resentenced for technical violations or being resentenced for new offenses, or a combination of a new offense and a technical violation. Now, I mentioned at the beginning, going back to those substance-involved offenders, what happens to them? And it turns out that substance-involved offenders are much more likely to be resentenced compared to other offenders. The rates of resentencing are 29% higher for those who are substance involved. And that's identifying them at the time of sentencing. Those who are substance involved at the time of sentencing are 29% more likely to be resentenced for any reason. They're similarly more likely to be resentenced for a technical violation. And they do experience more resentencing events. So these are people who are moving through the system, particularly for technical violations. There is actually no significant difference in the likelihood that substance-involved offenders would commit new offenses. So they're being caught up in technical violations, and that's driving their patterns of resentencing. However, there's some good news in that when you look at the group of substance offenders and you can compare the rates of substance-involved offenders who were sentenced to treatment at the time of their offense, they do better. They don't do better on technical violations or resentencing in general, but they are less likely to commit a new offense. When you sentence a substance-involved offender, in our sample, when substance-involved offenders were sentenced to treatment at the time of sentencing, they were less likely. We are not able to get at what treatment they might have received while they were under probation supervision, but if anything, that would suggest that this is a conservative estimate, because we know there are probably some people who received treatment that we're counting as not receiving treatment. I mentioned that substance-involved offenders are very likely to be involved with technical violations. And when we tried to break apart technical violations and find out just how many of them were specifically related to substance violations, we found that it was pretty high, that based on our most confident group of data which we're most confident that we have the real reasons for the technical violation, up to 50.9% of those who are resentenced will experience at least one substance-related technical violation. So that's a significant portion. And that the other thing we found is that substance-related technical violations are very common, even for those who are not identified as substance involved at the time of sentencing. We do see a higher rate of substance-related violations among those who are in our group of substance involved, but they are common across most offenders, which is again indicating that our estimate of substance involved offenders is not actually capturing all those who are substance involved, and that most, if not a substantial majority of our sample and justice involved persons more generally are substance involved. And then finally, knowing that these are very common, we wanted to try to put our finger on just how resource intensive these violations were. And we found that when you look at resentencing events, up to slightly over 30% are directly attributable to either substance-related technical violations or substance-related new offenses. And based on the outcomes of these proceedings in our sample, we saw that the substance-related violations, again, for both new offenses and technical violations, were associated with 270,000 to 553,000 additional days of justice supervision. And that's primarily in county jails and on county probation. And if you were to try to put a number on this statewide, so beyond the 47 counties in our sample, extending it more broadly and standardizing it to a 1-year period, we estimate that this costs the justice system $1.4 to $2.9 million just in additional supervision days. And this is based on a marginal cost, so accounting for the fixed costs of the justice system as it already operates. And this is also not counting additional resources that may be spent on the resentencing proceedings themselves. So based on our report, we put together several recommendations which are enumerated with more detail in the report, but broadly we identified that there are some notable issues with the sentence SGS web reporting module, and we are working to improve that. Primarily, we're working to reduce the use of global categories when districts report to us the reason for resentencing procedures, particularly for technical violations. We identified categories that make it difficult for us to really drill down into the level of detail and specificity that we would like to understand what's going on with resentencing and the reasons for resentencing. And so we're looking to reduce the use of those categories. And we're also going to recommend that there's an audit for completion, because we know that we mentioned that 11 districts reported 0 resentencing events and 9 others reported very low rates. In comparison, and also going through the site visits, we saw that there are different rates of resentencing proceedings when we look at county level records versus what is reported to us. So there's certainly a need for considering the completeness of the records that are reported to us. And we also like to recommend that we collect additional information, particularly looking at any type of treatment that individuals might have received while they were under probation supervision, to give us a better picture of what individuals are experiencing, especially as related to substance use. We also are encouraging we also are recommending that we assess offenders for substance use issues prior to sentencing. And this is driven in large part by the fact that we found such a high rate of substance involvement in our sample, and that the substance issues persisted into community supervision with high rates of substance-related technical violations and high rates of substance-involved new offending. And that was common across both individuals who we could identify as substance involved based on their offense type or by potential assessments, but also for individuals who were not. And so we know there's a group of individuals who are statutorily required to be assessed prior to sentencing. And yet that group is fairly limited to certain classes of offenders and certain places in the guidelines. And so by broadening the individuals that are required to be assessed for substance use prior to sentencing, we can hopefully better target evidence-based treatment and consider that as an option at sentencing for some people, and hopefully reduce the burden on the justice system of that substance use. And then, Ryan, can you go back one? Thanks. And then we also recommend that we would consider the use of non-incarcerative sanctions for substance-related technical violations based on the significant cost associated with those additional days of justice supervision. And as part of that, we recommend that we really expand the educational opportunities for practitioners in the justice system. We found in some of our site visits, for example, that not all practitioners felt comfortable with evidence-based practices. They just weren't sure what the best evidence-based practices were, and so they tended to defer to probation. However, because we found that there's a benefit of treatment at sentencing, we'd encourage for justice practitioners to be, particularly judges, to be exposed to additional information about what those evidence-based practices are, what the benefits, what the costs are, so that they can consider that when they're faced with resentencing decisions.
Great, thanks, Miranda. Just very briefly, I think as I noted in my introduction, the commission itself has been working on resentencing guidelines at the same time that we were doing this report and analysis, and some of those, the language that was adopted is complementary to our findings. So for example, section 307.4 says prior to resentencing, the commission recommends the court obtain additional information via risk needs assessment or a risk needs responsivity assessment to identify any rehabilitative needs that may be addressed at resentencing. I also think it's worth just highlighting a couple other initiatives that parallel this that happened at the pre-sentencing, as well as some educational efforts going on. So just very briefly, for all DUI offenses, there's an evaluation to determine the extent of the person's involvement with alcohol or controlled substances prior to sentencing. As was also referenced during this meeting, our sentence risk assessment instrument asks that additional information be obtained for non-DUI offenders for those who fall into the non-typical risk categories. And that is also an opportunity to obtain risk and needs assessment and responsivity prior to sentencing, to be thinking about the needs of the individual being prior to sentencing. Additionally, for those offenders who are under consideration for restrictive intermediate punishments in level 3 and 4, they shall have a diagnostic assessment of dependency on alcohol and drugs prior to that sentencing component or those extra elements. And then I'd like to just highlight two other things that happened before the resentencing hearing that I think have opportunities for the courts. One is the efforts that have been going on by the County Chief and Adult Probation and Parole Associations related to their evidence-based strategic plan. This really gets at what Miranda was talking about, related to educational component of officers who are supervising individuals and trying to connect them with the necessary treatment related to their individual substance needs. And finally, there is the opportunity for the Court of Common Pleas to establish a program to impose swift and certain and brief sanctions for technical violations prior to a revocation hearing. This program makes use of short-term incarcerated punishments up to 21 days without formal revocation procedures. I think that this report provides also the commission with some guidance as it moves forward with thinking about the 8th edition, and be thinking about specifically those offenders who are in our sample that currently fall within the level 2 of the guidelines, and be thinking about some additional, maybe pre-sentencing evaluations for needs assessment for those individuals to tap into the elements of substance involvement. So thank you for your time. I'll turn it back to Mark to see if there are any questions from our commission members.
Sure, and Matt, let me just pick up on one final point, and this is something Miranda talked about in terms of data collection. Later today, we'll be talking about the certification of compliance that the commission is required to do in the future related to the use of probation and the reporting of sentences to the commission. So I think there's a real opportunity as we roll out that certification process to really address exactly what Miranda talked about in terms of the full reporting, not only of sentencing, but of resentencing and better information on what is happening at that stage. So thank you for that. With that, I'll turn it to the judge for any questions, and then we'll move to parole.
All right, I know I have a question, but I'm going to hold off, see if anybody else has any thoughts or questions about this before I speak. If you do, you can just unmute, and it looks like Representative Stevens.
Thanks. So maybe I missed this, but I just want to make sure I understand this correctly. When you say technical violations, does that encompass all technical violations, or are these just substance abuse related technical violations?
So it depends on which number you're looking for. So when we mentioned that, for example, men were at greater risk of technical violations, that includes all technical violations. And when we say that technical violations drive resentencing, that's referencing all technical violations. However, we do in the last few slides talk specifically about substance related technical violations. Depending on the district, they can account for up to 50% of all technical violations, but I think the average is closer to 20% of all technical violations.
So if the average is closer to 20% of all technical violations, do you have a sense on what the other 80% of the technical violations, that we're seeing involve? I mean, are they failing to report? Are they not keeping an address? Any idea what makes up the bulk of those?
So unfortunately, we're not able to speak clearly to what the bulk of those technical violations are because of those global categories we mentioned, like multiple instances of any violation or any single violation. And so unfortunately, there are just some districts that report those for most of their technical violations, which undermines our ability to speak confidently about what the true nature of technical violations are in those jurisdictions.
All right, thank you. Mark, this is a question for you. Do you know, anywhere in the criminal justice system, and I get it that probation and parole departments probably try to look at best practices and things like that, but somewhere, is there any data about the relationships between some of the conditions that are imposed upon folks under supervision and their, I guess, rehabilitative needs? In other words, are some of these conditions that are being placed upon those in supervision completely unrelated to their, their rehabilitation, particularly in the substance abuse areas? Do you know if there's been, some data-driven or evidence-based practices put forward that probation and parole departments are following when they're imposing conditions on folks under supervision?
Yeah, yes, in two parts. One is at the county level. I think Miranda mentioned or Matt mentioned the evidence-based practices initiative of county probation and parole. And that really is focused on trying to identify what are the risks and needs, and especially the needs that can be addressed, and what are the sort of complementary conditions that would be imposed. But remember, the probation department isn't imposing the conditions, the court is. And so it's really important. That's why I think that initiative is so important, that collectively the county chiefs are really trying to put forth a blueprint and really make sure it's in the hands of judges and others to really promote those kind of best practices. And I think that's consistent with what Senator Street talked about with legislation, and what I think the commission's trying to do in terms of the guidelines, in trying to really reduce the number and the severity of all of these conditions, and also to make sure that they sort of fit what's necessary and not just like overloading. And I just say that on the state side, the Board of Probation and Parole has been working for many years to try to do the same thing, and trying to equate conditions of parole supervision with the needs and risk. And one thing, final comment, is with the Department of Corrections. They are looking at new assessment instruments like SPIN and other things that really focus on responsivity. Like, what's the case management plan that makes sense to promote, best outcomes from someone leaving an institution? And in some cases that, is less is more. And in other cases, it's being very targeted about what those conditions are that do the greatest good. So I think, a lot of work to do, but I think everyone's sort of moving in the right direction on this.
And I don't know if there's other questions, but because of what Representative Stevens, just to follow up on a question based on what he asked, there was a discussion about the substance abuse violation is approximately 20% and 80% being other technical. Is that correct?
I'm sorry. So it's our best quality data suggests that it's up to 50% of all individuals who are resentenced are given some sort of technical violation. However, if we consider all districts in that, the number is much lower, closer to 20. But unfortunately, we're not able to speak to, that's because we just don't have information about a lot of the technical violations when we do that.
And I guess my question is, how do you determine what's a substance abuse violation? Is that a check mark in the SGS web? Because when Representative Stevens said, are the others reporting issues, moving without giving updated information, et cetera, I tend to find that those are frequently as a result of their substance abuse issues. So I just wondered how that plays in. And the second follow-up question I have is, well, maybe we'll do that first so we don't.
Okay, sure. So I should, to clarify, when we say substance-related technical violation, those are directly attributable substance-related violations. So that includes check marks, for example, failing a drug test, or self-reporting drug use. It also includes if you were required to attend a drug and alcohol treatment, and then your technical violation is for failing to report to treatment. So it's the joint condition of being required to go to that specific form of treatment and not going. So we were very limited in that. However, I would certainly agree that a lot of the underlying reasons for other technical violations may be continued substance involvement.
Okay. And does anybody else have any other questions or comments? Because I want to ask about the resentencing, the slide that's up. But first I'm looking to see if anybody else does. Please just unmute and state your name so we can allow you to address the commission. Anybody else? All right, so my next question is, what I'm hearing is let's look at things to address the needs of the individual so that we can reduce the idea of incarcerating, as particularly this sample that you're doing, that they were not initially incarcerated. But for the court's purposes, there is that gap in time from where they come in front of you for the violation and where you get your information to determine what their needs are. And For example, 2 days ago, I have a woman that I'm very familiar with who has again come in front of me. She's been testing hot. When she came in front of me, she was clearly under the influence and testing for methamphetamines. So what do I need? She needs treatment. I don't need any special knowledge for that, but I can't make the recommendation. I'm not an expert of what she needs, but I'm not going to send her back home on the bus high on methamphetamines while I wait for a drug and alcohol assessment. So I'm just curious, what do you look at that gap time? Because for me, what I try to do is get an assessment as fast as possible. But for somebody who I think their life is at risk, I'm going to incarcerate them until I can get that. And then as soon as possible, get them out of jail and into treatment. Is there anything else you're seeing as an alternative or any other ideas that you can put out there?
I think, as the judge, of course, I think you would have to, in that specific circumstance, it sounds like incarceration for a brief period of time just to be monitoring and supervising that person is probably consistent with this recommendation, then to receive additional information to link them to whatever services are available in your county that meet the specific needs of the substance use or substance involvement of that defendant, because there are different treatment modalities. We have a best practice section in our report that talks about different treatment options for different types of substances and what seems to be the best or evidence-based in the literature related to that notion of treatment.
Thank you, Dr. Kleinman. Anybody else have any so before I ask anything else, I got to back up and read your 100+ page report so that I probably will have a lot of answers. Does anybody else have any questions or comments before we move on?
I just have one. John Rago, Miranda and Matt, in Allegheny County, this is somewhat related. RDA is going into court more frequently, and this is in regard to something Judge Tucker said, to either terminate or modify some of these longer supervisions. And I'm just wondering to what extent, if there's an issue of dependency in that individual's history, that RDA should be told to, take note of that and as he prepares for these motions to modify. Because if that's an indication of a risk to repeat their offense, I'd like, RDA to be aware of that. But we're happy that he's doing that. And he's pretty aggressive with it. And it's been going on for about a year. But again, this is a risk factor that he should probably be aware of as he's preparing all of these reviews. And
so
I guess the question is that something that we should bring to his attention or the other DA's attentions who are concerned about this? I know DA Vitone, for example, in Washington County, when Secretary Wetzel was faced with COVID and there's a lot of conversation between the DAs and the DAs Association and how to handle, all these people that they needed to help to get out of the system. I know Gene was very effective in saying he was concerned about people who had a history of substance abuse, not for any punitive reasons. He didn't want them to come out and do harm to themselves. And I know that affected Secretary Wetzel's thought process. So, this is just an issue. Again, these are more, I guess, broader discussions, but if there's a history of substance abuse or addiction, I'm just not sure how to flag that as they try to deal with all of these issues across the board.
Sure, and I understand it. It certainly is a complicated issue, and I think one of the challenging things in this is that we have individuals who, substance abuse disorders are likely lifelong for many people, and right. They will continue to struggle with this. I think one of the things that's important to remember is that out of our report that these individuals who are substance involved are more likely to be resentenced in general, but that's primarily driven by resentencing for technical violations, much of which may be attributable to failing drug tests. And the time to resentencing is also important. Most people in our sample who are resentenced are not failing early in their probation. The average time to resentencing is slightly less than a year. So they're able to maintain, compliance with probation for a long period of time. I think the other important thing to remember too is that there's literature that suggests that, individuals who are not in treatment on probation, but are just maintaining a drug-free status because of the abstinence requirements are some individuals can do that, but it rarely has long-term implications for their ability to sustain abstinence once they're off probation. So essentially, there are some people that will stay compliant, but can we really follow them forever to ensure that?
Okay, thanks. Thanks, Miranda.
I think we have to try to move along to the next topic. And if that's okay with you, Judge, I will move to state parole and actually combine the discussion of state parole guidelines and state parole recommitment ranges. What I just because of the time constraints, I thought I'd summarize the comments we heard on both of these issues, not to go into a lot of detail with it, allow some comment by members, and then we can have a fuller discussion during the commission meeting, during the policy section when we're looking at the parole provisions. So if that's fine with you, I'll proceed.
Yeah, that'd be great. And I'm going to step away for about 2 minutes. So if Representative Stevens, if you don't mind, in case something comes up, and I'll pop back in as soon as I can. Thank you.
All right, great. So to start off, the comments we received from the public hearings on parole, the original proposal starts at page 467. And for the parole guidelines, keeping in mind, these are initial guidelines. We have not had guidelines before. And so there were a couple of goals in mind. These are advisory guidelines that once in place will have to be considered by the parole board. But the statute's very clear that the parole board can continue to exercise discretion and use other instruments and information at its disposal to make decisions. And the chairman of the parole board mentioned that yesterday, that they will continue to use all of the information they have access to, including their internal instrument that they use to make parole decisions. So our role as a sentencing commission developing new external parole guidelines for consideration was to try to reconcile these things, try to come up with guidelines that that build off what the parole board is already doing and build off information that is available, but spending a lot of time to analyze and document those kind of practices and try to bring some greater transparency to the process, because this, for the first time, would allow for the public release of these individual information. And so what the commission did in starting was looked at the parole board's decisional instrument and worked on analyzing and rebuilding that. And I think the statute drove us towards considering two different aspects of decision making. One was a requirement in the statute that we use a validated risk assessment. And when we looked at the Department of Corrections and the array of risk assessments that they have available and use, we ended up with the LSIR as the best of what they have available that has been validated. And we spent especially quite a bit of time looking at the racial impact of the use of that instrument, because that was an issue that led us to drop some of the other instruments that they were using. So we felt comfortable in terms of the analysis of the racial impact for the LSIR and using that as the instrument. Having said that, the DOC is looking at developing or obtaining a new instrument that does a much better job on the responsivity side. And so we will continue to be working with the DOC, and when the new instrument is in, we would be evaluating that and seeing if, in effect, we would swap that in place of the LSIR. I know concerns were raised about the LSIR. We understand that, but at least our analysis found that for that sample, it was the best instrument that was available at the DOC and was validated. The second half of the consideration for the parole guidelines is sort of readiness for parole, because there's no right to parole, and the board has to feel confident and is required to consider first and foremost public safety. But what we found was that a lot of the decision making made around readiness involved the interview with the offenders, and that was very subjective. And so we spent a lot of time building what we thought were objective factors that came out of that interview that we could build into the parole guidelines. And so that's what we had presented. And so the comments we received related to the parole guidelines specifically involved an issue regarding that preparedness. We focus, one of the factors that we discussed with the board and that they take very seriously is acceptance of responsibility. And some of the feedback we received during the public hearing was that maybe that should be more focused on progress in rehabilitation or motivation in progress, because there are some individuals who continue to maintain innocence, and if they're not accepting responsibility, does that mean it's the end of the road? So that at least was one of the issues that was raised about considering preparedness for or progress on rehabilitation in place of acceptance of responsibility. I already mentioned the LSIR as concerns were raised about that as the instrument. As I said, our analysis found it was the best of what is available at DOC, and we're required to use a validated instrument. There were questions about the definition of violent offenses versus other offenses. Some of that is prescribed by the board's own statute in terms of violent offenses, and so we tried to use existing legislation and the standards that the board is held to build it into our guidelines. So we are, that is one of the things that helps to frame the decisions we came up with. There were questions or issues about the amount of weight that we give to the court and to the DA, the input from those and from others, from the generally from the criminal justice community or from the process, and that includes victim impact. Those are some existing provisions and some provisions that we are required to consider in the guidelines. So the weighting of it is, we use it as an example of a reason for an override from the recommendation. So it's not built into the instrument itself, but it's one of those factors that can be used to override the recommendation the commission's making. And I remember during public hearings, we talked about some of these overrides because they work in both directions. In one case, there may be an individual who is not recommended for parole based on the guidelines or any of the internal work of the board. But because the person is so close to maxing out, the board makes a decision that having some type of structured reentry is better than the person remaining in the institution not being paroled. So that would be an example of an override where the board sees that there's other factors in play that sort of supersede or override the recommendation that would normally be in place. In the other case, we might have someone that we feel and we recommend as being well suited for parole, but it could be that the statute prohibits parole. And an example of that is the statutes related to sex offenders, which require completion of treatment before being eligible for parole. If an individual maintains their innocence and does not participate in any of the treatment, the parole board is prohibited from paroling them. So that would be an override in the other direction. Even though we might recommend the person, they're not paroled. Again, these are advisory guidelines, and they're intended to, for the first time, have a transparent and open process whereby the public can better understand some of the decision-making by the board. And I think the second part of that is what the chairman of the board mentioned yesterday during our hearing, and that is that he believes that having those guidelines in place would be really helpful in bringing decision makers, the 9 decision makers and the hearing examiners closer together, having a common starting point for making a parole decision. We found that same thing with sentencing guidelines, where just having guidelines in place as a starting point promote conformity or more consistency. And the argument that the chairman made yesterday was that the same could apply with parole guidelines. So those were the key issues that were raised. I think there was one other issue in terms of recognizing that the Department of Corrections is responsible for supervising, providing programming, et cetera, for these individuals, and probably have the best insight into these individuals about preparedness for release. And so a lot of weight should be given to the recommendations of DOC staff. And certainly that's part of the process we have. We don't give it more weight, but we certainly give substantial weight to the process and the views of the DOC. So those are the issues. Again, I'm just giving you a high level kind of review of this. We can discuss it further, but in the interest of time, I want to move on. The final thing that's listed there is effective date of 1/1/2022. Even if these guidelines were adopted by the commission, submitted to the General Assembly, and took effect or could take effect at the start of next year, there's a lot of work that needs to be done to build the application for automating both the guidelines and the reporting process so that we can make this information available and do analysis. And so we envision we'd be partnering with a lot of other agencies, but we envision that's going to take a while. And so that's why we talk about a sort of a 1-year delay. But during that period of time, I think there's also the expectation that we would be working to pilot this with the Department of Corrections so that they'd be working with it. We could make any kind of adjustments necessary over the course of that kind of pilot period during the next year, and then look to fully go effective 1/1/22 for parole decisions being made then and forward. So any parole decisions being made January 1st of 2022 and forward. So those are the issues on the parole guidelines. I'm going to turn quickly to the recommitment ranges. So these are the individuals who are on state parole and have been revoked. And the starting point for the commission was, again, looking at current practices that the DOC, that the parole board has, and recognizing that we would have sort of a public side to that. We would have a public process about recommitment ranges. So we had to take into account statute, what the statute provided. We had to take into account what the parole board is already considering, and they have regulations that they follow related to recommitment ranges. And then we want to look at other kind of factors that come into play. So regarding the technical violations, we, like the board, viewed 2 categories of violations: technical violations and convictions for new offenses. Presently, the parole board has regulations in place that guide, that provide standards for recommitment upon revocation. One of the things that we're very aware of, and the parole board has really worked hard on, I think, is the idea that the first reaction to some type of non-compliance should not be revocation. What it should be is trying to effectively deal with that issue in the community. And so the board has worked to develop a sanctioning grid that is used in district offices and by parole agents to basically identify how to respond to issues, and especially technical violations, so that it doesn't result in a revocation. And so there is a whole procedure in place, and certainly there could be improvements. We've heard that. But I think recognizing that someone who is revoked or has a technical violation, that this is rarely the first incident that happens, that there's been a history leading to that, is purposeful because of this sort of internal operation at the field level. So I think we can spend time talking to the board about that and trying to improve that to make sure that you're filtering out violations as much as possible. But by the time a case gets to the parole board for a revocation hearing, although we might call it a first revocation for a technical violation, what we've heard and learned is there's a history of issues that led to that point. And then if that individual comes back a second or subsequent time, there's some issues in play there. So I think that helped inform the commission in looking at the statute and recognizing the statute itself diverts many technical violators to non-prison recommitments, to community correction centers or to other types of services. The commission used the boundaries of the statute, and then I think for second and subsequent offenders, basically built up a baseline of a recommendation for some back time. So, we can talk more about that later, but that's some of the reason why the commission built guidelines, sort of creating a floor in certain circumstances that doesn't exist in statute. The commission can decide to abandon that, but that was the reasoning for that. On the convicted parole violator side, the parole board, under its existing guidelines or regulations, uses very old sentencing guidelines to, in effect, rank order the seriousness of these new convictions and link to that back time recommendations. So what we've done is, in effect, codify that, linking it to the current guidelines and coming up with categories that link to the offense gravity score categories instead of this very long list of individual offenses for which back time recommendations were made. So it's a real way of connecting a new conviction offense that happens while someone's on parole supervision with the sentencing guidelines and with these recommitment ranges. And we can continue to look at that. We can continue to modify what those assignments would be, but the structure of linking those together and using the guidelines as sort of the rank order of seriousness of these new conviction offenses, I think makes a lot of sense, and does it in a systematic way that as the guidelines change, that would also change those recommendations under the recommitment ranges. One of the things that is not built into this, but I think that is worth considering as we move forward, is with the 8th edition guidelines, we have talked about building something into the sentencing guidelines that takes into account whether a person was under supervision at the time of the offense. And that could be someone on probation or someone on parole. And so to the degree that in the 8th edition guidelines, we build that into the sentencing guidelines, then I think there'd be an opportunity to look at the parole recommitment ranges and diminish the impact that we have on convicted violators, because you're addressing the issue at sentencing rather than at parole. And that gets to a broader issue, which is coordinating between sentencing and parole. If someone is convicted of a new offense while on state parole, there is not a standard process by which a person is first sentenced on the new offense and then revoked on the violation, or vice versa. It's a mix. It varies a lot. And I think the commission, in working with the board and with the AOPC, should be looking at whether there's a way to standardize that, because it's hard to have rules or procedures in place if you don't know who's going to go first. Is the judge first going to sentence and then the parole board's going to decide on the recommitment range, or vice versa? And then how do the two of those interact? And that's a frustrating area across that we heard about. And I think there could be some work done there. And I think what we heard in public hearings as a final comment, get to the initial points that are listed there. Things like whether you give street time for people for violations, There is a provision that allows that to some degree with the board, discretionary street time awarding for technical violations. I think that's a whole area that we should look at with the board and think about whether to build into guidelines. So there's a lot of things that we could continue to work on, but as the chairman said yesterday, with both parole guidelines and recommitment ranges, there would be a benefit of getting something in place to work from rather than continuing to sort of work away. And we've been working for a decade on this. So continuing to work away without having any kind of standardized thing in place to improve upon. And so if the commission moves to adopt and submit this and start this process, we have a year to work with the board to refine what we have. And then we have an opportunity to continue to revisit this and update it as we figure out a better coordination between the sentencing guidelines and paroling guidelines. So with that, I think I've recapped the issues we've heard. When we get to the policy meeting, we will have an opportunity for members to discuss that and to raise other issues. So with that, Judge, I think we're about done with the policy thing. We may want to take a little bit of a break before we start the quarterly meeting.
Yeah, so what are you thinking in terms of time? A 10-minute, 15-minute break?
10-minute, good?
Sure, it's 11 a.m. now, so if we're back at 10 a.m. from our little break, and we can continue from there, and I think Representative Stevens takes the helm. Thank you. Does anybody have any last-minute comments? Seeing none, we'll see everybody back here in 10 minutes.
Thank you.
Thank you.